Welcome to the AAVMC's Diversity and Inclusion on Air podcast. This podcast is a program of the American Association of Veterinary Medical Colleges Diversity Matters Initiative. The podcast explores various issues related to diversity and inclusion in the veterinary profession and provides AAVMC an opportunity to offer ongoing diversity programming to all of our member institutions, as well as all veterinary professionals. My name is Dr. Lisa Greenhill, and I'm the Chief Diversity Officer here at the AAVMC. Now, if you are a fan of the U.S. Supreme Court, because, you're really into that, like you're in luck, this is the show for you. So because we are at the near the close of this year's Supreme Court term, it's ending at the end of June, and typically the big decisions that everybody's waiting for, the most controversial ones, the ones that really kind of make history take pivots, those types of things get handed down and made public sometime typically in the next 6 weeks or so, right? So two decisions that we are really interested in this term are Students for Fair Admissions versus Howard and Students for Fair Admissions versus University of North Carolina. Now, a lot has been made of these cases and what they mean for the future of admissions in higher education. Oral arguments were argued last fall here in DC, and now we're just waiting. We're waiting. But we do know that there's a drop date, like at some point. They've got to do it by a certain point. So I am very excited to introduce my guest today, Dr. Sonya Gyjuan. Sonya Gyjuan Smith, my colleague and counterpart from the American Dental Education Association. She works upstairs in our office building. We hang out a lot, have a lot of work that really crosses over between our two organizations. And I am delighted that I have finally been able to get her on today's show. So welcome, Sonya.
Well, thank you. I'm happy to be here, Dr. Greenhill. I'm excited to have this conversation and am eagerly awaiting the Supreme Court, the U.S. Supreme Court's decisions, along with everyone else in June of this year.
Yeah. So I want to set the stage, and we had a whole conversation about this to our viewers and listeners, because so much has been made of these cases related to affirmative action. And so I kind of wanted to address that small bit before we get into the meat of the cases and what the cases are really about. So, Sonya, can you tell us what is affirmative action?
So when I think about affirmative action, we think more of it as a concept. Really, I think it was like 1961 when President Kennedy first used the concept of affirmative action. And basically it was part of an executive order related to federal contracting, right? And so in that, it basically said that contractors will take affirmative action, right, to ensure that applicants are employed and that employees are treated during the employment process without regard to race, creed, I think it was color and national origin, okay? And so the concept really initially applied to federal contracting, but we have used it as a concept that, in the larger sense, Lisa, that says that it is basically procedures that we're going to use to ensure that there is, to eliminate discrimination and there's no unlawful discrimination against applicants based on protected class. And you know that a protected class is age, it is pregnancy under sex, it's race, it's gender, it can be disability status, it can even be whistleblower. Those are some of the protected classes, but that's what people often leave out, that it has to be tied to a protected class. Because people oftentimes say, well, I'm going to sue because you, and the person's under 40, because, you treated me differently because I'm young. Well, that's great. But unless you're 40 or older, it's not a protected class,
Get some years on you. Get some years on you, right? So, and oftentimes we hear, that perhaps affirmative action didn't work or doesn't work the way, folks think it should, thought
Mhm.
it should, those types of things. So who are the primary beneficiaries of affirmative action and why?
Well, one of my other gigs in life is I've actually taught at a law school, at two law schools. And one of the things that I always found interesting when I would ask students, who are the primary benefits of affirmative action, quote, quote, they would definitely say African Americans would always be the first group, but they never actually talked about the group that has benefited most, which is basically white women, right? And so when you think about affirmative action, remember that it's really a benign concept term. There's a legal part of it, but we don't use it in the traditional legal way that it around federal contractors. Always, we've expanded it to admissions and other forms of hiring. And basically, affirmative action is supposed to address systemic racism and sexism. So that gets back to the gender part. So when you talk about affirmative action policies, have you noticed that people rarely bring up gender or sex discrimination when you think about it? So, but we know that there's data that truly does show us that the greatest impact in terms of people who benefited the most from Title VII of the Civil Rights Act of 1964, where it says that we can't discriminate based on race and gender and religion, national origin, has been white women. I pulled some data and it says that although women made up 35.3% of people receiving baccalaureate degrees in 1960, before affirmative action policies, were established in 1982, women were no longer underrepresented today when it comes to attaining college degrees. Actually, let's see, if we look let's see, 2012, it says the group's enrollment in colleges and universities for the first time women outpaced men was in 2012. So 72% of white women enrolled compared to 62% of white men in 2012. Okay, so those patterns really continue today.
Yeah.
We can think about it in terms of also not just women number of women graduating from college in terms of undergraduate degrees. We see it in dentistry here at the U.S. dental schools. I think it was approximately 4 years ago for the first time that the number of women enrolling outnumbered the number of men. And so by and far, the largest benefit of affirmative action has been white women under the concept of you're not going to discriminate based on gender, and you're going to take affirmative action steps to ensure that women are adequately represented in the workforce. You see it in pay gaps, We know that, something like white women still in 2019, I think white women still out earned Black women, like it was like $840 to $704. And so that data is true. It's not to say that that's a terrible thing, but what it does say is that we enter a time, and this is just Sonya's opinion, not her employer's position, that we have entered a time where we use race to divide us. It's a divisionary tactic. We aren't going to talk about women oftentimes because oftentimes people that are passing these laws, which are over majority men, they're going home to their wives oftentimes. And so they're not going to get up and stand up and talk about women. Not that we don't see attacks on women. We know that. We can go to the case law there. We're not even going to go there today. But I wanted to really stress with you how, when we talk about affirmative action, if you ask someone about affirmative action, what's the first word that comes to mind? Race.
Yes.
Race.
Yeah. Race.
And normally Black people.
Yes. Yeah. That is kind of the that's the narrative, right? That's the narrative around affirmative action. And for folks that are listening and watching, so you said, how many years ago was it, Sonya, that women out-enrolled men?
It was really 2012. It was 2012 where there was just like a sharp distance, that it wasn't even close anymore.
Wow. So, of course, you know that happened to us in the mid 80s. And
Right.
so we are now over 80% women in the colleges, US colleges of veterinary medicine here. And so, yeah, these are real issues.
Oh,
Yeah.
in dental, at the US dental schools, it was like approximately 4 years ago.
Oh,
That
wow.
it was only 4 years ago. But we're starting to see, Lisa, that's another show around women and men of color
Oh,
and enrollment. That's another show, but it was really around 4 years ago that women exceeded men in the application process. And so now, of course, we're starting to see women exceed men in graduation rates. So
yeah. Yeah. So before we move on to specifically talk about the cases, I have to apologize, folks, because again, Sonya and I are good buds. And so I just jumped all in here with the questions and did not even allow her to introduce herself. So we're going to rewind just a little bit and give Sonya an opportunity to tell us a little bit about herself and her work.
oh, that's so funny, Lisa. Lisa and I hang out regularly to have these philosophical conversations and debates. And no problem, Lisa. I am Sonya Smith, and I am the interim chief of staff at the American Dental Education Association, and I am also the chief diversity officer. I've been at the American Dental Education Association, ADEA, as we call it, for 5 years. Prior to that, I worked at the University of Tennessee Health Science Center as an assistant vice chancellor for student affairs, enrollment management, and associate professor. For 6 years, I was at the University of Nebraska Medical Center as an associate vice chancellor for academic affairs, the chief student affairs officer, and an associate professor in the College of Public Health teaching global health and human rights. So that was fun. And I did do some malpractice law things with medical students and things like that, and been a dean of admissions at Vanderbilt Law School. I'm a Vanderbilt Law graduate, a graduate of Vanderbilt University, the Peabody. I have a doctorate in higher education. I have a law degree from Vanderbilt. I have two master's degrees, a master's in education. Last year I finished a master's in global affairs from Arizona State Thunderbird School of Global Management, and I could keep certified, certified civil rights investigator, Title IX hearing officer. I could keep going. And so
for everybody to be clear,
yeah,
Sonya is that chick. Okay.
But I just have been really blessed with lots of opportunities, and I'm a perpetual nerd, Lisa. You know.
Which is why we are good pals, because the nerds love to hang out. So, but yes, she is really that chick, and I am so honored to get to work alongside you. So let's talk about SCOTUS cases. So students for fair admissions, they kind of got together, they sued Harvard and they sued UNC, arguments last fall. So who are these students for fair admissions?
Okay, so let's back up a little. So, well, maybe not. So, okay, so I wanted to just say that, remember that all of this kind of like started with the Bakke case.
Yeah.
Remember, it was the medical student that basically said that he was being discriminated against as a white student, mm-hmm. and they were holding like 16 slots for Black students. And basically the key proposition that you have to remember from that case basically is two things. One is that you can't have quotas, right? You can't have set-asides. You can have like goals and things like that, but you can't have quotas where you have a separate admissions system and you're setting aside a specific number of slots for a racial group. But the case also did, though, show that there are some cases in which, when you use what constitutionally they call strict scrutiny, under mm-hmm. certain conditions, you could use race as a factor. So those are kind of like, when I think about the Bakke case that kind of led up to this in the 1980s, that really get us to where we are. So I'm going to try to kind of like quickly take you through kind of like the cases, and I'll try to pause at the end of each case, okay? So the first one, as we know, is Students for Fair Admission, and basically they're a nonprofit group who opposes racial preferences in the admissions process. So they basically allege that Harvard and University of North Carolina, Harvard and UNC violated Title VI of the Civil Rights Act by intentionally discriminating the Harvard case against Asian Americans, and in the Chapel Hill case against whites and Asian Americans, okay? So they say you're intentionally discriminating against Asian Americans in the Harvard case. You're doing what they call racial balancing to get what they believe is a predetermined racial mix, okay? So they're saying that you're not just using race as a factor, as one of many factors, but they're saying race is the determining factor in this. And basically that if you are a person of color and you apply and they use this race as a factor, that you're going to get admitted. And then basically what they're trying to do is, if you remember, overturn the Grutter cases, if you remember, Grutter and Grotz. And so Grutter is the case that basically said, where the Supreme Court came back and said, you can be race sensitive in the admissions process. And in some cases, you can consider race as one of many other factors, and that is indeed lawful. And so remember that with the Harvard case, that initially Harvard prevailed in the initial suit that Students for Fair Admissions filed. In the U.S. District Court, Massachusetts, basically said that Harvard did not violate Title VI of the Civil Rights Act, Title VI, which prohibits racial discrimination for those receiving federal fundings. And we know everyone's receiving financial aid there. Right. So they basically said, the district court, that Harvard is using a multi-tiered process, and it's okay. That the admissions officers consider a single factor in many otherwise far-reaching ways, and that's okay. That the dean of admissions does share like what he sees as kind of like the goal for the student body in terms of the racial composition, but it's not a quota, it's not a set aside. If you don't meet it, it's not the end of the world. And they also basically say that that the allegation that Harvard is violating Title VI and discriminating against Asians in terms of doing any racial balancing is and using race as a determining factor is not true, and that Students for Fair Admissions also said that Harvard could use other race neutral criteria. In other words, they could basically achieve and have a racially diverse student body if they use socioeconomic status, for example. So there are all these wonderful experts who made lots of money doing this, I'm sure, but they basically showed that if they used socioeconomic status as a solution and not this race amongst these other factors, that it would reduce not only the racial diversity of the student body, but it would lower their entrance test scores, which was interesting, wasn't it? So the court used what they call strict scrutiny. And that's the constitutional standard. There's rational basis, and there's intermediate, which I'm not going to go into. Let's stick with strict scrutiny. And so strict scrutiny is when there's a federal or state action. It says that that if you're going to use a race conscious program, like, in the admissions process, that it has to be narrowly tailored to a compelling interest. Well, the compelling interest is the benefits of having a racially diverse student body. So what are those benefits, right?
Yeah.
And so the court has said that is a compelling state interest. And what the interesting thing is, the court really, in not only U.S. Supreme Court cases, but district court cases, they basically have yielded usually to the higher education community to say that the diversity of the student body is indeed a compelling interest, right? Yeah. So they really haven't questioned that too much, I think, because there's been so much evidence and social science research over time. And you have lots of employers intervening in the cases too, to say that it is indeed an important part of their business necessity mission. So they kind of like not question that. So in the Chapel Hill case, though, that was I think the Middle District of North Carolina, very similar. Like I said, Students for Fair Admission sued and said that minority applicants were being admitted to the detriment of white, Caucasian, and Asian American applicants in violation of the Equal Protection Clause of the 14th Amendment, and of course, Title VI of the Constitution. So the Equal Protection Clause basically says that we all deserve to be treated the same under the law. You can't treat us differently. With UNC, they also have a multi-tiered review process. It includes, they have like 40 admissions criteria that you have to go through there. And one of those is race, ethnicity, national origin. Similarly, court use strict scrutiny. They wrote, like, I think, Lisa, their court opinion was like 155 pages. I read all 155 pages. It comes down to basically, the court said that that UNC had a compelling interest in pursuing and attaining a diverse student body. One, it says that they accomplished it in the right way, in that it was necessary that UNC admit and enroll a diverse student body to include racial diversity. So they specifically called out an important part of a diverse student body is racial diversity. The other part of it, it says that they engaged in a highly individualized, holistic review process. And the key here is it is not mechanical, it is individualized. And that's a key piece to make sure that it is narrowly tailored and it is flexible, right? So that they could use race as one of these other factors in these 40 plus admissions criteria. So they ended up finally in saying that UNC had conducted good faith, serious consideration of race strategies that were race neutral, and found no alternative to, they found no, I think the court said something like, no alternative at a tolerable administrative expense. Wow. What that means, Lisa, is this: you don't have to consider every possible racial neutral activity, or else the analysis would never end. Right. But you have to make a good faith, considerable effort and consider the reasonable ones.
Got it. Okay. All right.
So I think that gives you kind of like a high level overview of kind of like the cases.
Right. So basically, we're really talking about this strict scrutiny piece. And for our viewers, I've dropped a few links. Wikipedia isn't always the greatest scholarly source. However, it'll get you what you need today. So what is the central constitutional question that has us all waiting around for the 9 justices to, tell us what's up?
I'm not sure that everybody agrees on that, but basically they want to know, they want to overturn Grutter, okay? The Michigan law case. And they want to ban race-conscious affirmative action programs for public and private universities, okay? That's the key thing. They want the courts to say that the use of race as a plus factor in the overall holistic admissions process does not align with past precedent. And that the other weird thing is, when Sandra Day O'Connor wrote the Grutter opinion, she, for some reason, thought that it was wise to say, and I heard her say in a speech that she regretted this, that she anticipated that in 25 years, we would no longer use race as a factor. So Students for Fair Admission, they're also saying it's been 25 years, it's a time limit, and also, when you hear about strict scrutiny, part of the constitutional question is always around, when is it going to end?
Yeah.
You know, what is the end point? And that, I think, is a hard part there's no answer to it. And when I think that troubles the justices also a lot. So I guess the constitutional question is if the use of race as a factor, really the way that each of Harvard is using it and UNC, Chapel Hill, that they're using it violates the Equal Protection Clause and doesn't treat us all the same under the law, and also violates Title VI of the Civil Rights Act, in which we're not supposed to discriminate based on race. And so those, to me, are the key constitutional questions. And I think, you know, it comes down to kind of like each of the specifics of the cases, because they're similar, but they're not similar. Right. That it could be that Harvard could win and UNC could not, because they separated the cases. So, and they're using similar processes, Lisa, but they're not using the same process.
Right. Okay. So I think we have a good kind of just broad overview, but folks are kind of freaking out, right? About what comes next. And of course, you know, during this time, we've also had the Fisher case out of Texas, which basically said, you know, again, narrowly tailored. They had these indices, and race was like one element of an index that was one of several indexes used in the criteria for admission. So, you know, by the time you got all these index numbers collapsed and crushed, like where is that huge benefit, right? That people are kind of thinking. And I think that the other thing that I kind of want to mention, for some naysayers that say, okay, well, why aren't we over this yet? Right? Why aren't we over this yet? And a few weeks ago, I was giving a talk to a specialty organization, and, you know, I sat down, and clearly we always hear like, it's been 400 years of, you know, oppression and those types of, and genocide in this country between, you know, our indigenous populations and African Americans, and certainly more broadly. But, you know, I'm a native Virginian, so we start the counting at you know, like 1507 or something like that. And so that's, you know, Jamestown, here we go. And that's when the clock starts. And that from then until now was 413 years, I think it was, right? And so then I sat down and said, okay, well, you know, oftentimes Gen Xers are considered the first generation, well, late Gen Xers are considered the first generation born truly free, right? After kind of after the civil rights Act passed. And so when you kind of deduct all of that, it ends up being 14% of the entire time that all of this stuff has been going on. So, you know, like, yes, the country is 200 years old, but the shenanigans around race in particular have been going on for twice as long. Right. So I think that it's important for folks who are always like, why aren't you over it yet? And I'm like, it has been 14% of the total time that this has been going on, at least in what is now known as the United States.
And also, too, the numbers haven't changed significantly. I mean, we know that in the health professions in terms of, we've seen some progress from women, but let's be honest, there's still lots of progress that needs to be made for not only women, but around issues of gender identity and sexual orientation. Let's just be honest here. And so when we look at the number of graduates, you know, individuals of color, you know, students of color, the numbers throughout the health professions have not moved significantly over the last, I'm going to just do the last 10 years. And so, I mean, even when you go back to Bakke, and Bakke was I don't remember, it's like 1980, I think it was 80.
It's 78.
It was 78, okay, 78.
Yeah, 78.
And so the numbers haven't moved significantly when you're looking at medicine, vet, dentistry, in terms of the graduates. And Bakke, you know, I thought about this too, when someone said to me, like, well, what, because, you know, you're trying to speak lay language and not lawyer language.
Right.
So Bakke basically said we can't use quotas, right?
Right.
And then I'm going to go back to strict scrutiny because I'm going to tie this back to what you're saying. And so, but then Bakke said there are instances in which you can use race as a factor, but it's going to trigger the highest scrutiny, the most rigorous scrutiny of the Supreme Court, which is strict scrutiny. Remember, I said rational, basis is lowest, intermediate, which basically usually deals with gender and also sometimes with inheritance rights for people whose parents are not married, if that makes any sense.
Oh, okay.
And then the highest scrutiny is usually, is race is one of those. And so when Bakke ruled, they said use strict scrutiny. It has to be a compelling interest if you're going to use race. It is a race policy. The race and ethnicity conscious program or admissions policy has to appropriately address equal opportunity consistent with the mission and educational focus after having evaluated race neutral alternatives. The problem that we get into that people don't like for me to talk about is that if I polled the group and I said, how many of you are doing evidence-based ongoing compliance and documenting that you have basically researched and or tried race neutral alternatives should you be sued?
Yeah.
If you have been doing that, you are less concerned about how the Supreme Court is ruling. The Supreme Court there's somewhere that it says that basically every 3 years, you should be determining and being able to show that you have been considering race neutral alternatives, that you're using a multidisciplinary team across your campus, and that you're documenting it and you're doing individual research, you're looking at research that others are doing. And so people have constantly asked me, what should we be doing? And I'm like, well, you should have been doing it anyway, because the court has been saying that. But one of the things that has bothered me, Lisa, is that we have not trained our admissions teams and committees to do this. And that our focus has been on making sure that they get the balancing right, I guess, per se, or that they know how to use race as a factor, but that we haven't taught them to do the compliance piece. And that if I walk into your office and ask for the evidence to show that you considered race neutral alternatives, that they're not necessarily there. And so part of the strict scrutiny test is that Harvard and Chapel Hill have to show that they have been considering, race neutral pieces. That's part of strict scrutiny. And then, of course, the last piece that you and I keep talking about here is that the race conscious admissions policy is reasonably limited in time and scope. So thus the 25 years. So, that's why, the Students for Fair Admissions, they're like limited in time and scope. This is not limited in time and scope. Right. And then the last one, of course, that is narrowly tailored to achieve the state's compelling interests of a diverse student body. Okay. And so going back to what you said. And so when I think about time and scope, I know Justice Connor used 25 years, but couch that time and scope just like you said.
Yeah. Put that into the larger context of the frankly oppressive behaviors in the US and the development of the country. So, all right, well, Sonya, we know, I think it was like on Halloween, Halloween morning, all the attorneys just, showed up across town here in DC at the US Supreme Court, and they held oral arguments that went on forever. Now, normally they get like each side gets, I think, like a half hour. You're supposed to do your thing, you get a few questions, and you're out of there. Now they usually go over the half hour, but this was like a marathon that day. And so, and oftentimes you see certainly on web pages like SCOTUS blog, which happens to be one of my favorite places to kind of look at information about Supreme Court cases. We're all trying to read the tea leaves. Like, so what magical thinking can we
the key takeaways from these arguments?
From the oral arguments.
Okay, so Lisa, I could almost take a long time for this podcast, but I will say this. I did listen to the oral arguments and I was trying to multitask, which wasn't quite easy. And you're right, it did seem to go on. But, you know, basically what we said, they want to overturn Grutter is what is happening here. And so I'm going to think about some of the questions that the justices asked. And so in the UNC case, I remember Justice Jackson pressed students for fair admission for evidence that race was being used as a determinative or singular factor in admissions, and whether it was appropriate or even possible to shun asides to correlate between race and other personal experiences like socioeconomic status, cultural practices, family history. So that was her pressing them. It's like, show that it is the determining factor here. You haven't shown that it's the determining factor in the UNC case. And she had to excuse herself, as you know, from the Harvard case.
Right.
And then on the other hand, Justice Thomas in the UNC case, he wanted an explanation of the educational benefits of diversity, given that Justice Thomas himself did not go to a racially diverse school, but still benefited from his academic courses. And then Kavanaugh and Barrett emphasized that UNC that Grutter imposed that 25-year, what they said, expiration date on affirmative action programs, and that there seems to be no end in sight to this, which is part of strict scrutiny, right?
Right.
And then in the Harvard hearing, Chief Justice Roberts questioned whether or not wanted to know whether or not granting a credit based solely on skin color is based on a stereotype. So he was like, how is this not stereotypical to say that when you if you want a racially diverse student body, how is it not stereotypical to basically say all African Americans that you are considering think a certain way? And because we say we don't, but part of that individualized review is that you are looking at statements. You are often you're interviewing people. So there are other things in the process so you don't get a monolithic view of people of African Americans or Latinx community, or you see what I'm saying, or American Indians.
Yeah.
And so that was his. And then let's see, I'm trying to think other things. Oh, there was one thing. So the interesting thing is that we think about this case in terms of admissions, but the justices start thinking about, wait a second, how about employers? And how does this fit within the affirmative action scheme, and except for, let's say, federal contractors. But they said, like one justice said something about, we consider the benefits of racial diversity when we hire our clerks, our judicial clerks here in the Supreme Court. And so she wanted to know, like in order to achieve a business need or an economic objective, that they had these amicus brief from employers who were saying that a racially diverse workforce was a business necessity. And so she said, so when you considered race neutral means, right?
Right.
And you can't get there, and you've tried and tried, can you go to race consciousness? At what point can you?
Yeah.
And Students for Fair Admission said you never can, it's impermissible. But she did raise that question. And then so they did start getting into voluntary affirmative action programs and DEI program by private employers as it relates to race and sex. And so we may get some of that from the Supreme Court saying that they're willing to go, depending on how they rule, that they're willing to look back at Title VI, which deals with all federal, programs, race, a national origin, creed, protected classes here, and also Title VII, which deals, I think I said Title VII. Right. Title VII deals with, race, gender, religion, national origin in the employment context.
Right.
So you're kind of getting something from the court that they may be willing to go back and look at affirmative action programs in private hiring, volunteer programs, not, like I said, federal contractors, which are under executive order.
Yeah. Okay. Got it. So, what I find really interesting personally about these cases is that, let's rearrange the deck chairs and would we feel the same way? Right. So, if it were, all of the other BIPOC groups bringing suit against, exclusion in favor or in lieu of white students and Asian students in this particular case, these particular cases, like, how would we feel about that? Right. Because we don't seem to question what competency as a cultural phenomenon.
Right.
I mean, competency, not like, okay, I can sew this together, but competency as a construct, a social construct. We seem to attach it to some groups and not to other groups.
That's true. That's true.
Right. And so I always find these kind of cases a kind of interesting thought process around, okay, so, would we feel the same way? Would we make the same arguments? Would we think about the contextual pieces around, like, it's only been 14% of the total time of marginalization and discrimination in this country? Like, so, I spend a lot of time thinking about these things, nerd things that we do. So, so the oral arguments happened, they went on forever. They were really kind of entertaining. Lots of folks were live blogging, tweeting, the whole bit. So, the general sense of things is that Harvard and UNC will not prevail under this current court's makeup. Tea leaves. So tea leaves. What do you think is going to happen?
Well, can I go back to something else that you brought up? It's like, I always, you as chief diversity officers, we are constantly trying to put ourselves in the shoes of other people.
Yeah.
So, there was a voter survey there's been voter surveys 2014 to 2022, and it basically shows that 60% of Asian American voters have consistently supportive affirmative action in university admissions, which is interesting. But there's also data that shows, there's the cooperative congressional, survey election study. And it's a survey, and it says, though, we've talked about that white women have overwhelmingly been the benefits of affirmative action, but 70% of white women somewhat or strongly oppose affirmative action.
Yeah.
I think part of that is because the way that we frame affirmative action, that when you're asked that question as a woman, oftentimes you aren't thinking that affirmative action applies to you.
Yeah.
So I just thought I'd share that with you.
Yeah. I mean,
part of our nerdness.
Yeah. Who's a part of that protected class? And are you speaking personally? Have you taken a moment of personal reflection versus kind of this societal piece? Right.
Yeah.
And it's interesting because part of that whole piece is like whether or not women want opportunities. And as I tell my daughter all the time when we are she has a big decision to make, and I'm like, well, let's figure out how many options you have. You need at least 2 options here, right? Like, because choice is, for me, I always tell her, choice is aligned with freedom, right? So choice is aligned with freedom. You actually have something to choose from, right? Now, sometimes they are like the lesser of evils, but you do still have a choice. And I think that when we are thinking about affirmative action, a lot of times we don't think about some of these choices that some of these programs actually have given historically marginalized populations, including and especially women. We just don't think about that. And now we, if you want to work, you work. If you want to stay home, you stay home. If you want to do both, you do both, like all of those kinds of things. And historically, that wasn't kind of our, country culture.
Right.
Yeah.
And then, I don't know, like I said, purely my opinion and everything. I really worry that the more our demographics change, not only here within the US, but globally, to me, this all ties to power. And the more groups that have been in power continue to see more people who are different from them as they view different, going to the ballot box to make changes, the more of this rhetoric we're going to hear. Now, this is my personal opinion, like I said. And what really bothers me is that we continue to buy into this narrative, and that the counter narrative around or even presenting a unified opinion that is contrary, to anti-DEI, anti-diversity, equity, inclusion, belonging policies, that I feel that there's just not a good counter narrative to it. And so one of my pet peeves is around critical race theory. I went to law school because I read Derek Bell and Patricia Williams, and critical race theory basically evolved from critical race jurisprudence. So you're talking to someone that's read hundreds of books on it. And so when I hear people talk about critical race theory, I'm like, oh my gosh, that's not even the definition of it. It never was intended, and Derek Bell's rolling over in his grave. But you have a group of people who have redefined it because it sounds like it's like the word of affirmative action. It's become the dirty word or a dirty phrase, and critical race theory now very much redefined it, made it their own, and that there's no narrative that positively is giving people an alternative view that is being heard so that you can make up your own mind. I'm not saying that you have to like it, but there's not enough out there. I feel like we're losing a battleground around just giving people the opportunity to make up their own mind with providing them with the information, and that we are weaponizing phrases like affirmative action, critical race theory, holistic admissions, race as a factor. We're just weaponizing them.
Absolutely. I mean, as we're recording today, the state of Florida has now made it illegal to have, DEI offices in their public institutions, higher ed institutions down there. And so, they might be the first, but they will not be the last.
They're not the first. I was at the University of Tennessee when the Tennessee legislature passed a law basically saying, getting rid of the University of Tennessee's diversity office at Knoxville and some of the other institutions, because some students had complained that money from student fees were being used for sex week. And so what came out of that, the office ended up shutting down, people lost their jobs. There was something where you as a student could check how you wanted your student fee to be used. That goes to the, drama, right? So they're not the first, but what you start to see is it had a chilling effect, and that it was often the white students that said, wait a second, you're shutting down the DEI office? It's not good. Wait, I can go somewhere else. And so then you start to see people change. And purely my opinion, I just think that if you want to see change, do you remember what the Missouri football team did?
Yeah.
When they refused to play.
Yeah, they refused
big time athletics. We, not ashamed to say here, many of our athletic teams, football teams, those winning football teams are people of color. And so when those athletes started to say, wait a second, we're not going to play unless you do something about this.
Yeah.
Policies changed.
Yeah.
And it's terrible but it was an economic thing.
Economic thing.
Because it was a recruitment thing, it was an economic thing, and it's terrible that that's what it took, but that is what it took. And that, that's what it took. And so I looked at Missouri and, all that was going on there with their president. Very similarly, I was at the University of Nebraska Medical Center when I-424 came through. I think there are like 8 states, if I remember, and I provided that in one of the documents that you're going to link to. Yep. That basically cannot use race as a factor or race in admissions and hiring unless, it's under some federal requirement. And so I was at Nebraska when that initiative was on the ballot. I remember sitting in my office and Barack Obama won the presidency. And at that same time, Nebraska passed that I-424 saying that you could not use race as a factor. So I'm going back to what should people be doing or should they have done? We knew that was coming. Our chancellor was very proactive at the University of Nebraska Medical Center, and he did everything that he could trying to educate people, but we kind of knew where the state was going. And so 1 year out, we started auditing what everybody should be doing now: admissions policies, pipeline admissions policies, scholarship policies, retention policies, awards, anything where you consider race as a factor, you should be auditing, doing an assessment, meeting with your attorneys. That's because you threw me off, I did not say my one caveat. None of this should be construed as legal advice. Nothing that I say should be construed as legal advice. And you should check with your institutional or personal attorney. So I forgot to say that one thing. But we started working with our attorneys and doing all these audits because we knew what was coming. And the question we asked ourselves is how we could, regardless of the outcome, support and recruit and retain a racially diverse student body. So we had a press release. That's the other thing you should be doing. We had a press release ready if the initiative passed. We had a press release ready if the initiative failed, and both of them basically stated our commitment to a diverse student body. Okay.
Yeah.
So other thing you should be doing. The other thing that we did is we wanted to make sure that all of the admissions committees throughout the Academic Health Science Center and the admissions officers were ready to be trained on how to use holistic admissions and support a racially diverse and a diverse student body, and within the bounds of the law. And we planned within 2 weeks, we had a workshop, day and a half, that rolled out, remote links, everything. And we invited, I think, the president of, Washington, the general counsel, where states where it had already passed, to ask them how they did it. And we were ready to go. And that's, to me, if you want to know what you should be doing, your audits, your assessments, talking to your general counsel about how can we do this regardless, looking at best practices, looking at states that, and some campuses where in California, I think Washington changed it, Michigan, some of the other places where this is already passed on a state level or via executive order, voter initiative, whatever, to see the campuses that are doing it well and what they're doing to do it. And then have your press releases ready to go, regardless of the turnout,
Right.
Confirming and reaffirming your commitment. And then within 2 weeks at the latest, that you are having some initiative, and it can be one of many throughout the year, to train and prepare admissions officers and pathway programs and admissions committees to support a diverse student body legally. So that's my piece of advice with 5 minutes to go.
There you go. All right. So, but back to my question, what do you think is going to happen?
I refuse to say. I believe that it's got that race conscious admissions as we know it will be struck down in some way. I don't know if they will come up with a compromise, and it won't go as far as I think some of the more conservative justices want to go.
Sure.
I think it won't go as well as some of the more liberal justices want to go, in that what I mean by well is that there won't be any change and that they will reaffirm Fisher 1 and 2.
Yeah.
I'm gonna remind you that Fisher 2 case was unique to Texas.
Right.
But Fisher 1 is more so the one we use. And so maybe the best that I'm hoping for is some type of compromise, so it's not totally struck down. What scares me is Sandra Day O'Connor saying 25 years.
Yeah. Yeah. Wow. Yeah. So I'm going to drop a link to the first Fisher UT case in the chat, and those will also be in the show notes. I can't seem to drop it.
And I gave, look, I don't know, lots of handouts because.
And there are a lot. Of
course, because this is me trying to the best of my ability, explain the law in less than an hour and talk about 15 million other things. And I know that in itself is not always the easiest task for people to understand. So I did want you to have some resources. Also, I did a key concept from a paper that I'd written. I cut and pasted it, key concepts around holistic admissions and race conscious. It gets into what a critical mass is. It defines race neutral policies. So I even define diversity in a larger context. I don't remember what all the terms are, but I knew that, I wanted to just provide some good resources.
Great. Wow. This has been worth the wait, my friend. And so thank you so much. It's been a really fun conversation and very, very enlightening. I was that young person back in undergrad who thought she was going to go to law school, and then I kind of ended up working on the Hill, was like, I don't need to go to law school. And so, but I still, of course, am quite passionate about it. So, I think that in the next 6 weeks, we will know. And after 10 years of lobbying early in my career, if you're suggesting that, the conservative wing of the court won't be all that happy, and the liberal side of the court won't be all that happy, then we might actually hit a sweet spot, right? Yeah. And so, in terms of negotiation, if everybody's a little unhappy, then that's probably, the
best we can do.
Forward. Yeah, that's our path forward. So with that, I would like to thank my guest, Dr. Smith. It's wonderful to see you. And thank you so much for agreeing to be on the show. I have been hounding her for like
9 months.
Yes, you're right. I actually started harassing her last summer in anticipation. Once the oral argument dates had been announced, I was already harassing her to be on the show. So thank you so much for spending this time with me.
Well, thank you for having me. Thank you. And hopefully I've provided something that will be of use. And, the key is, if you haven't started, looking at those policies, start, that's the key. And get ready.
Yeah. So, if this was Sesame Street, I would say today's word is document.
That's it. Today's word.
Today's word is document. All right. Well, this has been another episode of AAVMC's Diversity and Inclusion on Air. To my guest, Sonya, thank you again for joining me.
Thank you.
Be sure to subscribe to the show using your favorite podcast app. Also, be sure to like us and give us that 5-star rating on Apple or whatever podcast platform you're using. We will be back in a couple of weeks. We'll be celebrating AAPI month with a wonderful chat about breaking the bamboo ceiling for Asian American women faculty in veterinary medical education. So be sure to join us later this month. And with that, I will say goodbye.
Bye, everyone.